Okay.
6 o'clock.
Good afternoon, everybody, and welcome to this webinar on the road to Siena. This is the fourth webinar, and it is related to the problem-solving session about the choice between regulation and innovation. This is, how can I say, an old story with new characters. Every day news, new characters and facts. And I remember perfectly that Francesco Grillo invited us to discuss this topic last year, us as UI CDS to discuss this last year, and it is always a pleasure and an honor to participate to this conference, and the agenda is very, very intense. So it is this webinar is supposed to debate and help to build the proposal, the policy proposal to solve this dilemma, choice, trade-off. Maybe it's not a trade-off. This is something that we have to discuss between regulation and innovation. And the title also has specified that there is another question: if we need, as EU, an industrial policy for digital. So huge agenda. So I will give soon the floor to Francesco Grillo for the Vision Think Tank to introduce this webinar that will last an hour and 50 minutes. 15, sorry.
Thank you very much. Thank you very much, Roberta. I thank Natalia, Marta, Alessandro, who is about to come, Antonio and Massimiliano, and the students, Mariam and the second students, who has got a not easy to pronounce name, and also some of the people who are participating as spectators to this seminar. I just saw Peter Raffaele, who is one of the leader of in fact, of the political foundation of the Popular Party, Martens. So let me jump quickly into a couple of slides here, so that I then leave the floor to Massimiliano and Antonio. This is the fourth problem-solving session, regulation versus innovation. And we are looking to the case of digital. It's very true that, as Roberta just mentioned, we are basically having digital as a permanent feature of the conference on the Europe of the future. It's very big. It is changing very much, a lot, mostly because technologies change at a pace that lawmakers cannot parallel at all by definition. And let me, however, before having Massimiliano to present the position paper that we have now, and which will be developed further before the conference, to give you a few hints about the distinctiveness of the Siena Conference. So if we can go, Greta or Valerio, to the next slide here. So it is not, as you can see here, a convegno. This is something that we very much are used to in Italy. And it's not even an academic conference. It is what we call a platform for problem setting and problem solving. We are developing such a thing. It's very ambitious. It gets not only some inspiration, some vision, but a lot of perspiration in the implementation. So we are very much working on it. We are, in fact, involving all 5 political foundations of the big 5 political parties. We also invited, by the way, ID and Left. We will put together business, media, academics, and policymakers. And we are looking to problems that are complex by definition. For instance, the digital, no? How do we strike a balance between regulation and innovation? Or how do we solve the trade-off? It's very much about putting together people coming from completely different domain, no? Not just computer scientists or not just lawyers, experts of competition law, but we will need political scientists, economists, etc. No? We will have people coming from all big EU countries, big and small EU countries, but also from outside Africa, USA. We had people on digital coming from Australia last year, and of course we will have quite a number of people coming from Britain. And again, it is a project, not just a conference. Start before with this problem setting and solving groups. It's not just about doing problem solving, but also problem setting. Really understand the nature of the problem that we are talking about. And we will continue afterwards because we really intend to do even more advocacy of the ideas that we develop in the Pontignano paper with some multi-partisan approach. And this will also imply very much even more the partnership with the political foundation, the universities, like very much the European University Institute, the University of Siena, the Institute for European Policymaking at Bocconi, and we will probably also have Luis getting on board very, very soon. So this is it. Our approach is a little bit, if you want, a little bit like a third way, no? Between the sort of 20th century dream of federalism, which we probably think is a little bit a dream of the 20th century, and sovereignist, you know? So this is a little bit like an approach that probably is helping us to create this multi-partisan post-ideological dialogue. Massimiliano, I would say the floor is yours on digital. Thank you.
Yes, thank you very much to Francesco for this introduction and to Professor Carlini for chairing the session. Okay, I will share this slot with my colleague Antonio Manganelli. So I will make a first introduction to the paper, to the main goals and ideas behind this introductory paper, which is meant to be discussed today in preparation for the conference in September. I just introduced the main ideas, and I would like to create the framework and then leave to Antonio the objective to present some more specific ideas on the digital regulation. We divided our intervention in this way. So in order to set the scene for our analysis, first of all, I would like to share with you some of the basic ideas that we are using for analyzing the topic. Of course, we are focusing on digital. We are focusing on this idea of making I wouldn't speak too much about the choice between regulation and innovation, but I would rather speak about the challenge of how to regulate innovation, and on the one side, looking at the speed and the specificity of innovation in the digital markets. But on the other side, since me and Antonio in particular, we have a legal background, we are also very interested in the I would say innovation of regulation, which is the other perspective. So because this is an area where the European Union is acting as a very innovative regulator. We might not necessarily always agree with what the EU is doing, but if we look in a broad perspective, we are witnessing the EU as a global regulator in this area. It is to be discussed whether the EU is becoming a benchmark for regulation of digital markets. It is one of the points that we raise in our paper, is whether in this area of digital regulation we are witnessing an example of the Brussels effect, which is a topic very much discussed in recent years. We are not completely sure that this is a typical example of Brussels effect, maybe not, but certainly it is one of the points to look at how the EU is regulating this vis-a-vis other competitors, and whether the regulatory choices made by the European Union are a benchmark for other countries. So we hope to investigate that today and also during the conferences to see the point of view of business, because it's very important to see how business is happy with the European Union regulation, how the business sector can become a co-regulator in this field, but also it's very important to see how the EU is regulating this field and whether the EU regulation is effective, how it is perceived by global business players, but also by other competitors. Because it is not a specificity of the digital market that the EU is acting as a strong regulator. The EU is a strong regulator in most of the sectors. We have to consider that the EU has a specificity as a strong regulator, which is, I would say, in its DNA, and this is resembled in many areas. The EU always has a need to regulate in order to create a level playing field in the internal market that other regulators do not have in such a way. So there are some specificities that I think it's important to recall before looking at the specific ways in which the EU is approaching regulation in the digital market. Another point that we raise is the interplay between the specificity of regulation and the need of an industrial policy. And Antonio maybe will draw a bit more on this point, because even there it is true that the EU seems to be less effective in, let's say, promoting innovation, but it is not, there is a correlation, as it is written in the paper, between the EU regulation and the less innovation, less strength of the European players, but correlation doesn't mean causation, as it is written in our paper. And this is actually one of the points that we would like to discuss at the conference. So actually there are many issues. Another very interesting issue is the question of proportionality, because even if we assume that regulation is needed to, let's say, encourage business innovation, but also to protect consumers, which is another very important topic in the European regulatory environment. Even if we assume that, we need to discuss what is the appropriate level of regulation. So the principle of proportionality is one of the principles that we raise in our paper, and we think it's important to talk about how proportionate should be the regulation in order to balance the different interests. So these are some of the issues that we present in our paper that I think you all had the possibility to read. And having said these in general terms, now I would like to leave the floor to Antonio to make a few more remarks on some specific points which are more relevant for the digital regulation, and so that we can have a broader perspective before leaving the floor to the discussants. So Antonio, you can go on. Thank you.
Yeah, thank you, Massimiliano. And yes, Massimiliano synthesized very well our position paper, the main points that we like to discuss in Pontignano. And I think one point that is always good to start from and to underline that digital markets are very different, and digital markets and services are very different from traditional network industries, for example, which are usually the sector that are considered the regulated sector because the intensity of regulation is very high, or anyway, any other market and services, traditional market and services. And so are different the main actors, the main digital actors. And that's caused at the beginning, I mean, talking about 10, 15 years ago, some problems in approaching the public policy and the regulation for these service markets and for these actors. The first big difficulty is that we labeled as regulatory capacity, which is a label that the OECD has been used in some report, and which we think is very effective in order to define the ability of public policymaker to regulate a certain phenomena. The main problem were the marked and very high asymmetry of information that policymakers had with the stakeholders in the digital market, because there was a very low understanding on how digital markets work, how the algorithm works, what is the impact in those markets, and that of course represents a problem. I mean, the asymmetric information is always something present in markets, because of course companies has more information than the public, but the regulatory tools that has been developed in time allow the regulator to make the traditional companies to reveal those information. While for digital market and digital services is very difficult, because the functioning of those markets, in which I will not enter into detail, of course, and also because usually the institutional design of public policy and regulation is traditionally set and implemented at national level. So regulators are used to regulate a company that has a national dimension or a multinational dimension, but anyway with company established and working and functioning in each member state, while of course digital markets and digital company as a global nature and function in a very different way. So that was the overarching reasons for which regulation started to appear in European markets later than the policymaker would have liked to regulate this phenomena. And that's one of the point, of course. The point is between a trade-off between the regulating in order to minimize the risk of some harmful impact on markets and society of digital service and digital markets, but at the same time not to hamper innovation. And as Massimiliano rightly said, this is not a trade-off in itself. It depends how you regulate this phenomenon. And that's the main point of our paper. Try to, and the debate that has been running in Europe for the last few years, what is the main, the better, the best, the more appropriate regulatory mechanism, regulatory tools for the digital markets. And of course, the European Union regulated those markets, has been regulating digital markets in the last few years quite intensively, I would say. We reported a list of the main pieces of legislation that has been enacted in the last years, and which was part of the previous report. And you can see the number of acts and the number of provision, but of course the number of acts, number of provision in itself doesn't give an effective signal on how the regulation is bad or good, but just give an idea that the policymaker, the European policymaker, really want to regulate these phenomena. The risk is that regulation, which in itself we think it's appropriate to be introduced in the digital markets, but the regulation should be designed in a way not to hamper innovation, not to over-regulate, those markets. So the main point is to check whether the regulation that was introduced is a regulation that is fitting for purpose for digital markets and services, or there was the use and the transition of some old regulatory mechanism of the network industries in the new digital markets, which could be problematic because, as anticipated, those market works in a different way. So the main point we highlight is the fact that, and also Francesco highlighted at the beginning, the main difference is the speed on which and the pace on which those markets, technology, business model develop in digital market and services, which in itself it's problematic for regulation because, of course, regulation is retrospective. You regulate something that you have already in the market. But if those markets are really changing very quickly and very easily, and first of all, also mostly they can adapt to the introduced regulation in order to elude or anyway to have a lower cost imposed on companies on that regulation, then regulation could be very much ineffective and also not having also some unintended effects. So regulation, first of all, should be composed of a general provision, so not a detailed regulation, because general provision could be more easily adapted to the evolving market circumstances. But on the other side, general principles are more difficult to implement because, of course, the exact meaning of those general principles can be defined only ex post at enforcement level, when the enforcer or finally a judicial appeal really establish and define whether a certain market circumstance or action really fall into the scope of the provision. So there are trade-offs in designing the provision, and the general principle could be better fit, but that should be accompanied by either soft law guidance by the enforcer, which can specify and describe the definition of the concept they want to implement, or adopt, and both mechanisms has been adopted in the act that we listed, adopt a regulatory dialogue or a co-regulation approach in which, as a default option for regulating digital market, in which the rules and the provision is decided in agreement between the policymaker and regulated entity. Of course, this kind of approach is possible when the regulated entity are few companies. So when you have an asymmetric information, so an asymmetric regulation, so a regulation which is applied only to certain subjects. Otherwise, a regulatory dialogue would be impossible for asymmetric regulation applying to all, like the GDPR, applying to all companies in the market, while it's very possible and maybe even appropriate for a piece of legislation like the Digital Market Act, which is asymmetric and regulated only certain company, the gatekeeper in the core platform services. Another point that also Massimiliano highlighted is the fact that digital regulation, just because of this enhanced trade-off between regulating, establishing some efficient and fair outcome in the market and society, but not hampering innovation, should really embrace the proportionality principle, which is a general principle of the EU law, but sometimes is not adopted and leave room to a precautionary principle, which impose a very strong restriction of regulated entities in view of a maximum probability of effectiveness. This, of course, would imply very strong costs on regulated entities and also inefficiency in the market. And how to embrace and adopt the proportionality principle in digital markets. One way is what the Artificial Intelligence Act does, so a risk-based regulation, implying a gradually stringent restriction for circumstances and actors in accordance to the expected detrimental risk for the economy of society. Of course, also the risk assessment is something that can change with business models. So also the risk-based regulation should have some evolving and adapting mechanism included. And in order to also find, and then I stop here, to find a balance between these two things, is to one very interesting tool that was introduced in the Artificial Intelligence Act, but it has been also used in some financial regulation, are the regulatory sandboxes, which would be very interesting regulatory tool. That basically regulatory sandboxes are a regulated, a control environment in which market actor can introduce new technological tools, new services, new business models, and the policymaker or the regulator, whoever is in charge of managing the sandboxes, check what is the impact on the market and society and consumers of those services, of the technology, in order to understand whether a compromise in this trade-off between regulation, so minimizing risk of negative impact and innovation, could be fine. Again, here is something that policymaker and the regulator has to be careful of, it is that, again, the asymmetric information, because of course the companies could have much more information on the effect of this technology, and so in a way there could be a regulatory failure in assessing the outcome of the sandbox. And so on this thing, in fact, the last point is about the implementation of regulation. One big problem is the implementation of this regulation. One kind of problem, the asymmetry in scale between national regulators and global company, has been tackled by the European Union by focusing on a more centralized regulatory approach at the European level, while traditionally regulation network industries was the regulatory framework is designed at European level, and then you have a directive at European level, the need of transposition of the European directive into the national legislation, and then a national regulator. Then you can have some coordination mechanism between Commission and national regulators, but still the active regulation is performed in the traditional network industry, is performed by national regulators. While for digital markets, it depends on which pieces of legislation, but the most important, the DMA and others, the DSA for the very large digital platforms, is the European Commission, the regulator, the direct regulator. And this is a novelty in the European legislation, regulation legislation, which in a way, I agree, try to match the different scale, because of course having a larger regulator could be more effective. And another point, that the most recent piece of legislation are regulations, so are directly active in the market, no necessity, no need to be transposed into national legislation. This also creates a more stringent harmonization at European level. And that's it, more or less. That's it. And that very last point is about, we are talking about a lot of innovation. One thing to match the asymmetric information would be even if it's not easy for different reasons, that also regulators and policymakers embrace and use the new technology in order to regulate and, for example, to assess the impact on the market of certain services. So, for example, regulators start using artificial intelligence tools in order to control the compliance of big tech with the rules that are being introduced in the market. And the very last point, which I leave it very open because we don't have
you had a lot of last points.
That's true. The very last point, because it comes to my mind continuously, is the fact that, of course, next to regulation, we need an industrial policy that give incentive to new technology to be developed also in Europe. And I agree very much with Massimiliano that the fact that Europe is falling behind is not because of regulation. It would have been fallen behind also in absence of regulation. The difference between Asia for certain aspect and the US is the socio-economic context, but just for that, the industrial policy is very important in order to complement a good regulation in order to have both minimizing the impact and incentivizing the development of new service and technology.
Thank you, Antonio and Massimiliano, for this position paper. I read the position paper and I have a lot of questions as well, but it is not my role here. I wanted just to say that I found very interesting this the fact that you stress this the issue of the asymmetry of information, and I would add also the asymmetry of skills and competencies, on which you touched upon with the last note, that the use of technology by the regulators, but also in general the capability of the regulators to attract brains and technical skills. And also I found interesting this sentence that regulation can indeed prompt innovation. It's not necessarily a trade-off. It can also be a kind of regulation that nudge innovation toward a direction or another one. But this is just to say that the problem setting is full of rich of ideas and things to discuss to start the problem setting that is the base to advance the proposal for problem solving. And to discuss this, we have Marta Cantero and Natalia Menendez-Gonzalez for now, because Alessandro Gropelli did not join so far. Marta Cantero is a lawyer herself. She's associate professor of information technology at information technology law at the University of Tartu, and she's also a research fellow at the Florence School of Transnational Governance. She studied a lot on private regulation, that is interesting, but also on the impact of, on the Brussels effect, on the impact of European Union regulation in the global governance, in the global scenario. So I would give the floor to Marta for the first intervention with 5 minutes. Marta, is enough?
I'll do my best. Absolutely. Yes. Thank you so much, Roberta, for the introduction. And thank you, Francesco, for such a nice invitation to comment on this paper. And congratulations, of course, to Massimiliano and Antonio for the paper so far, which I have enjoyed. So I'm going to fulfill my task within 5 minutes. So I should move on directly to my comments. So I have structured my intervention in 3 points, and if I have time, I might touch upon the fourth one. So the first one is, of course, on the Brussels effect. And already Massimiliano mentioned that we should ask whether the EU is still becoming a benchmark for regulation in digital markets. So in this sense, what I'm missing perhaps from the paper is the discussion on whether any potential legal transfer actually triggers questions on whether law can actually be transplanted or not. I remember during our group chat conversations over WhatsApp the last few days, we were talking about different animal spirits and what happens with the different animals across different jurisdictions. So whether such legal transplants, if they happen, whether they cause irritation or whether they create new forms of interlegality. So the GDPR serves as a very good case study for that, because there was an initial moment of kind of like opposition to the GDPR, but then it slowly became like a benchmark. Whether that is true also for the DSA, DMA, AI Act, etc., and all the rules that follow afterwards, it remains to be seen. But still, what is missing perhaps not only in the literature but also at the level of like policy discussions is to study whether and how the EU policymaker is dealing with that issue of interlegality. We have a very good example, which is the EU-US Trade Technology Council, but it remains to be seen what is the practical application of those discussions. So that opens like a very nice angle that has not been yet perhaps considered. And this takes me to my second point, in which I want to talk about the proportionality principle and the broader spirit of EU rules and policies. And this is connected with the previous one. So whereas in the US, the approach is more like market-oriented, in the EU, we have an approach towards market regulation, which is entirely different. And more recently, we have this right-based approach. So this is something to consider when talking about like how to implement EU rules and policies in a context of multi-level governance, because together with having to transplant the rules outside the EU, there is a problem of how to properly and effectively like apply the rules intra-EU, so that we have this particular issue that is the result of like the complexity of the institutional design inside the EU. Antonio, I think he mentioned like the necessity perhaps for some sort of like soft law guidance in this regard. And come on, we both have written loads about telecommunications regulation, right? So if I tell you the example of termination rates in wholesale market, that didn't end up well with the Commission recommendation. So I would like to see what other mechanisms together with soft law may also underpin that, because like the proposition of using soft law is a good one, but we know that in itself is not enough. And yeah, that kind of like brings the issue of, again, the constitutional legitimacy gap, which is not the core of the paper, but maybe it can be also incorporated in that regard. So my proposal would be like to perhaps further refine the issue on proportionality, taking into account the problems of multi-level governance problem, and perhaps put it in connection with the principle of effectiveness. This was like thoroughly studied in consumer law legislation, for instance, but I kind of like miss this debate when it comes to digital policy and regulation. And then my final point is on co-regulation that we have also talked a lot. And essentially here, I have like a slight disagreement with the part of the paper where it reads that the primary objective of co-regulation, or regulatory dialogue, as you also call it, is to prevent over-regulation while avoiding a deficit of regulatory intervention. So here, while this is true on the paper, I might disagree, because in practice, co-regulation is not preventing over-regulation and is not avoiding a deficit of regulatory intervention. It's not preventing over-regulation because we still indeed have like a lot of rules that in some way they legitimize co-regulation. So the DSA is a very good example of that. I don't want to stem myself on that at the moment because it's not the core of my discussion right now, but like it also does not show that there is an intention to actually avoid a deficit of regulatory intervention. Quite of the opposite. They're trying to provide this meta-regulatory framework, for instance, to private companies, and in particular to big tech, as to how they take the certain decisions. And then I have a final point concerning the precautionary principle. And then at some point in the paper, there is a question that says, when and in what capacity should the regulators intervene? And then my question would be then, like, based on the above, perhaps the question is like, what to prioritize? And here we need to talk about, or think rather about, like, the problem with uncommitted regulators. And this is a particularly kind of like endogamy problem of the EU versus long-termism. There is a lot to discuss and to unpack there, but I will leave it there by now since I don't want to take any longer. Thanks a lot. I'm happy to develop any further.
Thanks, Marta. I give the floor to Natalia Menendez Gonzalez. She's a research associate at the Center for Digital Society at the EUI, and she's also has a legal background and at the crossroad between innovation and regulation. Natalia, the floor is yours.
Thank you, Roberta, and also thank you, Francesco, for the kind invitation. And I also would like to thank Antonia Massimiliano for giving me the opportunity of reading the paper. I think you managed to unpack in, I would say, quite a short and concise paper, a lot of very important issues. So congratulations on that. And as Marta did, I will also structure my intervention, I would say, in three main points. The first one being kind of a critique to the paper, in the sense that I think in the paper you kind of provided a hint of an issue that I consider of utmost importance in the topic, which is the public and private divide. And by this, I think you mentioned this in the context of the regulatory capacity of regarding digital platforms. And with this, basically what I'm thinking about is the fact that many private companies are providing digital infrastructure for many of the services and products that we are using, or we are, for example, as consumers acquiring in the digital age. Some of these products and services are also fulfilling a public role, let's say, or a public function. And I'm thinking, for instance, in the case of the pandemic, for instance, some networks that were provided by Meta, Facebook, I think at that time were of, and this was said by Mark Zuckerberg, were of utmost importance to maintain the internet traffic. So I think this adds an additional layer of complexity when we are discussing about regulating innovation, because the role that private companies are doing and what we have to regulate is not as simple as it used to be. And this intertwines with a lot of things that you mentioned in your paper. I'm thinking, for instance, asymmetry of information. I was very recently in a workshop with where some researchers were doing ask some digital platforms about data for conducting research, and the platforms in some cases did not provide the data, or if they provided the data, they provided in a very, I would say, censored way. But the thing is that if we depend on these platforms, or if we depend on these services in one way or another, this kind of asymmetry of information, of course, it could be regulated. But again, how can we regulate something that we do not fully understand, not just by lack of skills, as you mentioned in the paper, but because we lack of this information? And then another point that you mentioned in your paper that I think intertwines with this issue is the geographical scope. So most of these, for instance, if I think again about a digital platform, most of these platforms are not located, for instance, in the European Union, are located outside. It is true that some regulations, for instance, I'm thinking about the GDPR, provided as a solution that if the personal data of a European citizen is processed, then the regulations are applicable. But then I would say, and actually it's not just my opinion, there's some scholarship about this, this is not enough solution. And for instance, this could also be seen in the case of Clearview AI, this facial recognition company that allegedly did not process facial images of European citizens, but in the end it was seen that that was the case. But at the same time, when data protection authorities try to find them or try to open a process against them, they denied the jurisdiction of the data protection authorities because we do not process data from European citizens. So the authority of these data protection authorities, or what they say or what they tried us to do, is not applicable to us. Then the second point, and here I would like to be a little provocative, is when you mention the sentence digital regulation is indispensable, and I would provoke you saying, is it really? Because I think it was Antonio, you mentioned the retrospective character of digital regulation, and I fully agree with you. We have artificial intelligence systems way before having the Artificial Intelligence Act. We had the internet way before we had regulations that were applicable to the internet. So I think here the issue is more not regulating the technologies, but more the societal impact of these technologies. And I would argue here, and this will connect also with my third point, that to regulate the societal impact of the technologies, we already have in place regulations that could be of application. And I'm thinking also, because it's kind of my area of research, but in general, fundamental rights, regulations, or human the European Convention of Human Rights, for instance. Sometimes I think we underestimate the capacity of these regulations to be applied to technologies. It's true, I agree with you on the point you made that it's very difficult to apply big principles to very technical and very, I would say, to the nitty-gritty of these regulations. But, and this is my third and last point, I would claim here that the key point is not regulation, but enforcement, which is also something that you point out in the paper, and I fully agree with you. I think the key wouldn't be having all this regulation, which I don't think per se is a bad thing, but sometimes I think it's not enough, and it helps only just to obscure the landscape, but how these regulations are enforced. And in this sense, I will just point out one issue, which is the number of different supervisory authorities that these regulations bring with them or already did. So now we have data protection authorities, we have a AI office at European Union level, but we also will have national authorities in charge of enforcing in one way or another the AI Act. But we will have also at the same time AI system providers in charge of kind of enforcing compliance with certain certain aspects of the AI Act regulation. At the same time, we will have authorities in charge of enforcing the DSA, the DMA, which in some cases will be competition authorities, but in other cases, for instance, I think in Italy will be the authority in charge of cybersecurity. So basically, long story short, I think it will be extremely difficult to enforce all these regulations, having such a vast array of different authorities, also at different levels. So we will have, in some cases, for instance, Spain, we have, I think, 7 data protection authorities, including obviously the national one, but also all the regional ones. So we have the regional levels, the national level, and then obviously the supranational level. So I think it will be extremely difficult to enforce this regulation, which to me, it's the main point. And I will conclude my intervention just by giving you a suggestion. I don't know if you had the opportunity to read it, but since you mentioned Anu Bradford and the Brussels effect, she published very recently a paper called The False Choice Between Digital Regulation and Innovation. I think it's very up to the topic and contains some of the ideas that you already mentioned in the paper, but also expands on other aspects. So I thought it would be interesting to read it and also for further discussion. Thank you very much.
Thank you, Natalia. And before giving the floor to Francesco, Massimiliano, Antonio to reply to this, for their answers, I would like to ask. I mean, first thing is that this is a work in progress to prepare the paper, and that will be discussed in Certosa di Pontignano. So, in case you have some notes of your intervention, Marta and Natalia, it would be very much appreciated if you can share them. Second, the rapporteurs, the students that are here, Mariam and Seyeda Midreza, if they want to ask a question, questions, have feedback or reaction to both the paper and the intervention of the discussants, or if there are.
Yeah, I have a question. Yes, I have a question for Maria Marta, and I want to know that what is, in your opinion, best or most efficient way to prevent overregulation? Because, as you mentioned, you think the co-regulation or regulatory dialogue will not be the best tool. So, what is the most efficient way in your opinion?
Thank you, Maria, for the question. I think this is an answer that in some way Natalia has already provided. So improving the enforcement structures, there will be less need for regulations. So that will be one answer. And then a second answer, which is like a problem that is particular from the EU structure, is like the fact that the EU Commission is divided in different DGs and there doesn't seem to be any or much at least coordination among them is also like in my opinion, not that that is necessarily true, but it might be one of the reasons that explains why we have like overlapping rules or regulations. But that's my short answer to a very complicated question.
Okay, thank you.
Roberta,
Any other questions?
Yeah, there is a question from Peter Felle and maybe even from somebody else from the spectators. Peter, can we? Here we are.
I'm sorry, I didn't notice. I didn't see the.
Yeah.
Yeah, you can speak.
Can I now speak?
Yeah.
Okay, thank you very much. I have 2 points I would like to mention. First of all, I like very much this expression of innovation of regulation. I think this is something which is not emphasized enough also in the political communication. You know, the usual critics about overregulation is very much related to old forms of regulations, but I think the EU should emphasize more on pointing out to new innovative forms of regulation and communicate this to the public. That would contribute also to what we indeed call sometimes Brussels effect. And this is very much related to what Maria mentioned on the multi-level governance issue, because there are frictions between these different levels of governance, and regulations is a good or bad example in many ways why things don't work at all. The second point is indeed more the new tools and the parliamentary control. You pointed out that there's a lot of bodies created to supervise different aspects of this digital world on the European level as well as on the national level. I have sometimes the impression that the core, that means the parliaments, have sometimes lost control, and this is a fundamental problem of democratic theory, because they are the last instance of control, and with distributing control power to bodies which are not necessarily legitimized by democratic process, I think you run into a very fundamental question how our systems are balanced and not creating more asymmetric relations within different institutions. Thank you.
Thank you, Peter. Francesco, may I ask a question?
Yeah, of course.
Yeah. Now I was adding other topics. I was wondering that we are speaking of when we speak of effectiveness and also of the asymmetry of information, is something that cannot we already have some useful test of these issues? I mean, DMA and DSA are here, are in force, and some decision has been, some cases has been open. So don't we have some symptoms at least of these, if these are more or less working or not? How is cannot we do in this occasion also like a first assessment, a first evaluation of this first year of regulation? Because now the regulation is here and it is working or not working, and maybe we can a bit elaborate on this. I don't know if it is off the topic of this paper and of this discussion, but if it is more or less working, okay, maybe it was not impossible. No? If it is proved that no, it is not, because it is a mess, because the asymmetry of information, because of the lobbying of the companies, etc. Yes, this was my question, and I propose to have the last to follow the same order: Francesco, Massimiliano, and Antonio.
Okay, three very quick things. First of all, on your very last point, we have certainly a more robust evaluation of the GDPR, for the very reason that GDPR has been the very first, so we have a number of years, and the evaluation seems to say that the impact of GDPR on the competitiveness of Europe has been not necessarily positive, let's say. Number two, no, I have a very big, to me, some questions, a big question probably for Antonio and Massimiliano, because we basically did not touch the very big point of the industrial policy, or if you want, the digital policy, no, the question of the investment at the EU level, no, which was also in the very title, no. And so my question to Antonio, who confined this very question of the industrial policy in his third last point. Antonio, if you can elaborate a little bit, you know, how do you see EU-wide industrial or digital policy meant to make the EU more competitive, you know, vis-a-vis the United States and China? Okay, these are the two question slash comment, and then now the very third point on Natalia, when you mention it's a very big key word to me, knowledge. You said something like we do not know exactly what is going on. I don't know if you got it right, but I do believe that we do not know what is going on. Not just because we are missing some technical knowledge about how large language models work, which is also true because it's a sort of black box, but because we still do not have enough knowledge to understand what is the impact of that technology, call it artificial intelligence or whatever, on, you name it, education, healthcare, insurance, and so on and so forth, you know? And I mean, to me, that's something that we are missing and that probably we should sort of govern, you know?
Who goes first? Antonio or Massimiliano?
Massimiliano, go first.
Okay, yes, thank you. First of all, I thank all the discussants, and in particular Maria Marta and Natalia and all the others. And as Professor Carlini was saying, it will be useful if particularly Marta and Natalia can send us at least some bullet points of your very interesting remarks on the paper. This can be useful to frame our revision. And there are many issues that were raised in the different questions. I think with Antonio we will have some discussion, and so we can revise and improve the paper. Certainly some points, I will just pick up some points. For example, I think it's important to talk more, maybe we can expand a bit the analysis of the Brussels effect and the choice between regulation and innovation. This can be certainly a topic to be expanded. Also, this topic that was raised by Maria Marta on whether co-regulation is actually preventing over-regulation and maybe the effect of these can be maybe expanded a bit more. On the mentioning the precautionary principle, I have some doubts on these. This is an interesting point. I think that the discussion can be framed under the proportionality principle rather than precautionary principle. But I think we are talking about the same thing. It's just a question of terminology. But this certainly can be another topic where we can expand a bit the discussion. And on the other point, on the remarks of Natalia, I think a point that is related to also what was said by Maria Marta in different terms, if the reference to the geographical scope of regulation, I think this is also regulated in the analysis on the applicability of the Brussels effect, because my personal belief, this is not very much in the paper, but this can be expanded for sure. I'm not necessarily convinced that this is totally falling under the Brussels effect. There can be some issues of attempt of the EU to, let's say, have an extraterritorial application of European Union law in this field. So this is something that needs to be better investigated, certainly. And we are talking about new legislation, and so it's difficult yet to assess that. But there can be, as in other areas of EU law, of recent EU law, an interplay between the so-called Brussels effect and the more traditional extraterritorial application of European Union law. This can be another topic that could be expanded a bit. On the another point that was raised by Natalia, whether do we actually need a regulation or can we do with existing regulation, more general regulation in other fields? And this is also something where we could further discuss. I'm personally convinced that we do need regulation, but of course, there might be a point here whether the EU, in regulating the digital market, is considering its own legislation or the interplay between the new regulation and the existing regulation. This might be an interesting point, because in my experience, not in this area only, but in EU law in general, there is a tendency when there is new regulation not to consider existing regulation in other fields, or not to consider this enough. So this is certainly a very interesting point, I think. About the other issues, the question by Peter Effele, I also think that there is a point about the democracy issue, and this is, I think, a general trend of recent EU law, that there is a centralization, an exclusive and sometimes excessive regulatory role of the Commission at the expenses of the Parliament and other institutions. This is a broader topic, I think, that we can see whether we can insert something on this, or we can leave it for the discussion in September at the conference, but this is certainly an interesting point. And then on the other points, maybe I leave the floor to Antonio, maybe to say something.
Okay, and thank you, Massimiliano. Before giving the floor to Antonio, poiché we are already running out of time, we have a question in the Q&A, and I don't know if we can give Dante.
We have Dante on. Okay.
So Dante, okay, can you step in?
Yes. Hi, can you hear me?
Yes, perfectly.
Great. Nice to see everybody. I have a question, and it's a maybe higher level question, but here in the US, as you well know, the saying goes, the US innovates, China replicates, Europe regulates. And that is a boutade, of course, but there's some truth to this. And the age-old question of how innovation and regulation interact it's been applied in many sectors. One of them, of course, being the financial sector, which I happen to know well, and where essentially regulation is always running after regulation, and we could talk about that. But I guess the big question I have for you, listening to this very interesting seminar, and thank you for that, is really about Europe and how you all think about that. And the big question here is, I think Antonio talked about it a little bit. He talked about socioeconomic reasons at some point in his intervention. Why is Europe so behind? Why does Europe not have a platform company? Why are we in a position where we might, in a world that is decoupling, have to choose technologically between one or the other hegemon who are going in their own way? It's a generic question, and maybe it doesn't have as much to do with what you're discussing today, but I'd love to have some views from this distinguished audience. Thank you.
By the way, that is Professor of Management at Harvard Business School. He was shy, so let me...
It has to do, and Antonio is so good that he will answer in 5 minutes to this big question.
No, it's a very important and crucial question. Unfortunately, I do not have an answer, and I'm not well placed to answer to this question. It's a very complex. It's also a bit out of the scope of my main expertise. I mean, I'm dealing more with regulation and competition policy. So the industrial policy. I mean, there are what I meant in the sentence, which is very true. I think that the fact that Europe is lagging behind is not caused by the regulation. It's not caused by the fact that Europe is regulating. There are much more substantial issues, socioeconomic issues, which are not. I cannot. Maybe Francesco is better placed to answer to this question than I am, because it's very much something about economic policy and the interaction also maybe of the economy in Europe, and it's something I do not really. I cannot answer. For sure, what I can say is that can testify that the European Union recognizes that and is slowly developing, next to its regulatory policy, also some industrial policy. For example, in some different ways. Of course, there are some funds that are allocated to the to certain services. For example, I'm more expert about, for example, the telecommunications or the development of a high-speed network, both mobile and fixed network. There are targets that the European Union is setting, not only in connectivity, but also, for example, development of the number of companies that are using artificial intelligence tools, or the number of nodes of edge computing in Europe. So the European Union is looking at industrial policy in a peculiar way, for example, setting targets, saying that Europe to 2030 should reach those targets, somehow regulating in an incentive-based regulation. For example, telecommunication is very much something that is used, regulation in order to incentivize the investment of company in the markets, and also funding, providing some funding, maybe not enough. Not sure, for example, if we compare the US, it would be a nice comparison, comparing the US markets and the European market, what are the public funding allocated to new technology? Not sure whether, I mean, US is much more in advance, is innovate much more. Not sure that the public funding are more. Of course, there is another reason. There is a very different fiscal regime. There is a different insurance regime, health regime. I mean, all these things in a way affect the ability of companies to innovate. I mean, there was something, an indicator. I mean, we can talk in different ways. There was an indicator developed by the World Bank, doing business indicators, which is not specific for digital markets. You can apply to all industry, but you can see there are a lot of indicators and parameters that can affect the ability, the capacity of business to develop. And of course, it's something more spread in the socio-economic environment rather than related to regulation. And then I will just to briefly answer to some of the comments which were super interesting. Thank you very much for all your comment. First thing I want to highlight that, of course, this paper is not an academic paper, as you have seen. I mean, it's a very policy, very high-level paper which try to approach certain topic in a technical way, I mean, legal or economic technical way, regulatory way. But of course, for each page of this paper, if you want to write an academic paper, each page could contain 3 or 4 papers, because we are dealing with a lot of topics, of course, which are approached in a very high level, but to give an overarching view of the thing. The comment is that, for example, to answer to Natalia, that's true that, for example, the need of regulation, that's true that internet was there before the DMA, for example, but the internet 15 years ago was different, something completely different from the internet now. The internet was something very decentralized. You didn't have a centralized system with global actors that are conditioning the internet dynamics and the market dynamics. 20 years ago, the internet was something very decentralized. The rule was an etiquette. There was also the Declaration of Independence of the cyberspace that Barlow drafted, JP Barlow drafted in 1996, saying, okay, you government have to stay out of this is our world. We do not need, we do not want your rules, like in a natural contractualist approach that the rules are developed by the society, by the internet. Of course, the internet nowadays, and since 10 years ago, since 5 years ago, is a completely different thing. There are actors that have unprecedented power, economic and social powers, which of course need to be regulated. And we try thinking about other existing law. Competition, the first thing that was applying competition law to big tech, for example, which proved not to be effective. Cases run for years and years because digital markets work in a different way. I mean, there is no clear consumer harms, for example, because a lot of digital platforms that are two-sided market offer zero price service to consumer. It's very difficult to find the consumer harm in a static environment. You have to look in a dynamic environment. Or it's very difficult to define the relevant market because big tech are overarching different markets and services and using data from one market to monetize in another market. So all these things made competition law very difficult to apply. That was the reason because the DMA was enacted. So it's true that there were services, but market changes. And just because market changes very fast, it could reach a certain point that they need to be regulated. The point is to understand when and how, mainly. That's what we are discussing, how to better regulate. And about enforcement, I very much agree with you, still, Natalia, that in fact, I don't expect, I will be scared about having the same pace of production of a piece of legislation in the next European legislation. I hope the next European Commission will focus very much on the enforcement of the existing piece of legislation. And that's another point on the enforcement of the existing pieces of legislation, and also the coordination, because it's something that we mentioned in the paper, and also Massimiliano mentioned. There are pieces of legislation that are being issued 10 years apart. The GDPR from, for example, the AI Act or the DMA that are interplaying between each other have been enacted 10 years apart. And it's a geological area in digital market. Things are changed a lot. And that's very true that very often pieces of legislation are not coordinated. For example, I issued a policy, much more developed policy paper for the SERE, which is a think tank in Brussels, about the coordination of the Data Act and the Digital Market Act on cloud services, because we have to go into the details of each services. And there are a lot of problems of coordination. It's not easy. Those two acts are not really talking very well each other. And the other thing about supervision, I very much agree with that. The fact that there was a centralization on a side, and then like for a policy, complementary gift that the Commission gave to member states because of centralization, gave some supervisory powers to some authorities, national authorities. That has been creating a proliferation of a plethora of national authority with different competencies, and something also that it's a very important point I always mention to the people in the Commission are mentioning, that they are not specifying, because of course when the legislation gives competence to a national authority, they cannot identify the authority because it's national, it's for the national government to identify which authority has to enforce that. So because of how politics work at national level, not in all member states, but in most member states, there are new authorities generating, because of course you have to appoint new people there. So politician has more power to appoint people. So there are expanding the number of regulators because the legislation say a national authority. What instead the legislation could do is could link certain competencies, not identifying the authority, but telling, for example, that the authority which is in charge for applying the electronic communication code should also be the one applying the Data Act, for example, just to give you an example. So in this way, you don't identify the authority, but give anyway some constraint to the proliferation of the authority. And the last 2 points on Maria Marta, which I didn't quite get your last point, which I think was very interesting, but I'm not sure I got it right. But maybe if you send some bullets, it could be okay. Great, that's great. I could clarify more. And about the thing that you mentioned about the termination, I mean, that's something I've been studying for years. It's called termination. There was a regulatory failure. The problem was not this act, but that the Commission wanted to regulate termination as a market power issue while it was an externality issue. So it didn't use the right regulatory approach. Then we can talk about this if you want, okay. But I wrote some paper about it. I mean, that was a clear point of regulatory failure in the electronic communication regulation, which, I mean, was really because of different, but that's a regulatory failure. So they didn't use the right regulatory approach for there. And the last point on Roberta about the impact assessment. I mean, for the last legislation, the DMA is too early indeed, because you are still on defining the compliance strategy of the company, so you don't know what impact. The problematic point is to understand what you mean for impact assessment, because you can have an assessment of the effectiveness of regulation, what you mentioned, so the output of regulation. So if regulation, the piece of legislation is constraining the company, is leading the company to the behaviors that the regulation is imposing, or the outcome of regulation. So how, that's something that more Francesco was talking about. So when talking about the competitiveness, the impact on competitiveness of the GDPR. So what impact had the GDPR, what outcome had the GDPR on the general socio-economic environment? There are two different issues, and the impact assessment are always very problematic to do. I mean, in the European legislation, you always have some regular periodic impact assessment in order to revise the regulation. But sometimes, most of the time, I would say, those impact assessments are done in a very superficial way, not very deep analysis. And of course, it's very difficult. The most difficult thing is the outcome. And of course, the competitiveness, I mean, is something to be expected. The GDPR is an impact, negative impact of competitiveness. Of course, on the other side, you have the protection of fundamental rights. How to weight these two different things to find the final number, to understand if it's good or bad regulation, it's very problematic. So for sure, you can have different impact and then have an overall policy evaluation. But it's very difficult to have a technical evaluation whether piece of legislation is working bad or in a good way, because you can have different meaning, could attach different meaning to label to good and bad.
Thank you, Antonio, and thank you, everybody, for this super interesting discussion. I'm not, can I say, the job that the rapporteurs have to do is not easy. And as Francesco was saying, maybe it is challenging to add the part on industrial policy, because maybe based on this and on the paper as integrated with the observation, with the discussion, we have a clear diagnosis. These are the problems, and also some proposals on how to address these problems: proportionality, effectiveness, asymmetry of information. But the steps, this is another step to say, okay, so told at this point, which kind, I mean, I guess that your view is that a complementary industrial policy is needed, but we don't know enough to say what, to have proposal on the content. So I propose that, I mean, the proposal that can emerge to address the points that you emphasize in the paper is already a great step forward. But if we want to have the industrial policy in the seminar, maybe we can also pose this as an issue to the AP Foundation, to the politicians. No, maybe it is at some point, at some regard, it is also their role. What do you think, Francesco? Maybe this
no, I think that we probably need to make a small effort to answer the very big question that Dante was asking us from the United States, by the way. If I have to give a small answer, really in a nutshell, to what Dante was asking, is that probably we in Europe have missed for many years both Joseph Schumpeter and Karl Marx. It's quite interesting that if you look to China and the United States, they both had a very centralized vision of what technology can do. In the United States, everything started from the Pentagon, in 1969. In China, yes, it's even more evident, such a thing. But they also had the animal spirits, Joseph Schumpeter. They allowed companies to fail. They allowed business to be disrupted. Not that European business are not disrupted by technologies, but we are more like on the receiving side, observing the impact of the big revolution without not very much to say. That is not exactly true that we have nothing in Europe. We had Skype, which was Spotify, that were quite disruptive. We are now having Mistral, ASML, so we have something. We do not have a platform at all. There is no European platform which can even remotely compete with China and the United States, and it's a big question. So, Roberta, to cut a long story short, I would say that Antonio, Massimiliano, Mariam, Maria Marta, Natalia probably want to do a little bit of effort to answer this very big question, because that's one of the two questions that we are posing to ourselves. Which regulation? which can even encourage innovation, which I do not like industrial policy as a word too much, but we need to understand whether the EU as such can do something which is different from what, by the way, France is already doing. France has got an industrial policy on digital, and not only France, also Estonia, as Maria Marta very much knows, So it is a question that we should somehow to probably develop a little bit further.
Thank you, Francesco.
Grazie mille.
Thank you, everybody, and looking forward to the Certosa conference.
Thank you. Bye.
Bye.
Grazie.
Thank you.
Thank you, everybody.
Bye-bye.
Bye-bye. Thank you very much.